Welcome back, everybody. Some really heated text messages back and forth there in the Leon Jacob case out of the Houston, Texas area. Really nasty stuff. The prosecutor was able to pin this guy on. Elura Nanos is here in the studio. Elura, good to see you again. It's been a long time.
Thanks, Aaron. It's great to be back.
Okay, so what do you make of this? I mean, this guy just thought he could get on the stand, thought he could convince everybody that he really didn't hire the hitman, that he really was just suggesting things that might have happened. Look, people were not buying this, but it's, I guess, fun to go back and look at this guy just get pigeonholed by that prosecutor again.
Yeah, I mean, this is kind of the textbook reason why defendants usually do not testify in their own defense at criminal trials. It rarely goes well. The only time that it ever really goes well for a defendant to take the stand in his own defense is if he's got something great to say and he's really good at saying it. And this guy is neither. He has no good explanation. He's not credible. He doesn't look like he's telling the truth. So none of the sort of theatrics that help a defendant or help any witness really are working in this guy's favor.
Look, the prosecutor was right on the ball in this case. People were commenting on Twitter. People were emailing me saying, hey, look, she did a great job with the evidence. She was on top of him every time he tried to, in some opinions, weasel his way out of the facts. And we're watching that go down yet again.
Right. I mean, the only way that this really works, in a way that could have helped him, is if he got on that stand and said something like, you know, here's how that was taken out of context, and gave some kind of alternative, very credible explanation. But truthfully, he didn't really have anything like that to say, so it's just not working for him, and we know that it doesn't work for him.
All right. This is great testimony to listen in. Let's go back to the Leon Jacob case in the Houston, Texas area.
Let me ask you, do you recall back on March the 2nd of 2017 texting Valerie McDaniel saying, did you know that you have been laid 44 straight days in a row now?
I don't recall the exact date or what I wrote, but it sounds like something I would have communicated to Valerie.
And if that's correct, you'd agree with me that that would have put you sleeping with Valerie McDaniel just 7 days after you and Megan broke up, correct?
If the math is correct, yes.
Okay. So when you tell the members of this jury that you're heartsick over Megan, that's not really true, is it? Because it sure didn't take you long to move on, did it?
Matters of the heart and how you feel are subject to the way you feel at a moment. I mean, you're asking me to get up here and say that I'm some womanizer. That's fine. You can characterize me as that. It doesn't make me guilty of solicitation of capital murder. I have no problem sitting here and saying that I slept with Valerie 7 days after Megan and I broke up. But I'm not on trial for being a womanizer. I'm on trial for solicitation of capital murder. So you can assassinate my character all you want up here. It doesn't make me guilty of what you've charged me with.
I appreciate that, Mr. Jacob, but my question was, isn't it true that just 7 days after you and Megan broke up that you were sleeping with Valerie McDaniel?
I think he answered.
Absolutely.
Okay. And so when Laura Thurlow was testifying, do you recall your lawyer asking her a lot of questions about your behavior at the time that you were having her help you with things?
Yes.
And do you recall her characterizing your behavior as bizarre?
Yes.
You mentioned that Valerie, when your lawyer on direct examination asked you who Valerie McDaniel was, you mentioned that she was your girlfriend / your common law wife, right?
We could be characterized as common law married, yes.
And it was important for you to be characterized as common law married when all of this went down, wasn't it?
It's just a reality of what the situation was.
Right. Would you agree with me that you had numerous conversations with your mother about the fact that it was really important that you and Valerie be considered common law married?
You'd have to refresh my memory, but yes, I remember something like that.
And do you remember telling your mother that she needs to make sure that your belongings stay over at Valerie's condo, because when this trial comes up, you need to be able to say that you two are common law married?
I don't believe it was in reference to the trial. I believe it was in reference to the fact that I was not on bond at the time, and Valerie had bonded out before her death, and I wanted to be able to go live with my wife if I was given a bond.
Well, didn't you say when she takes the fifth, she'll be able to say we're common law married? Wasn't that your concern?
Not particularly. I may have said that, but I was more concerned that if I got out on bond, I'd be able to go back to my home.
Because that's the only place she had to go, right?
It's where I would have wanted to been.
And when Mac McDaniel found out that you were actually staying over at Valerie's house, you knew he was upset about that, didn't you?
Of course I knew he was upset about that. He blamed me for their divorce.
And when he found out that you were over there, you knew that he and Valerie came to an agreement that as long as Natalie was over there, you weren't supposed to be over there, were you?
I was never made aware of an agreement between the two of them.
So you didn't know that you weren't supposed to be there when Natalie was there?
No, I did not.
Valerie never told you that she was upset with Mac because he didn't want her daughter around you?
Can you repeat the question again?
Sure. Valerie never told you about the agreement that she had with Mac?
Not that I knew of.
We continue to review that testimony in the Leon Jacob case in the Houston, Texas area. That defendant who was on the witness stand right there was accused of hiring a hitman to take out his ex-girlfriend, who of course survived because the hitman turned out to be an undercover policeman. And he and his new lover were also accused of hiring the same hitman to take out the new lover's ex-husband. Talk about a love trapezoid, I guess you could call it here, because it was more than a triangle. They had to really unravel all of this, and the defendant got on the witness stand, tried to get his way out of it, and it just didn't happen. We're in the midst of that testimony, and it was certainly gripping. The prosecutor was on top of every time he tried to get his way out of it. We're going to take a break now. We'll be back with more of that testimony in just a moment here on the Law and Crime Network Live. Welcome back, everybody. You're watching Law and Crime Live, and welcome again to those of you watching on the Crime and Investigation Network. We are continuing to review testimony in the Leon Jacob case in Texas. This is a case that I analogized a few minutes ago as being a love trapezoid of some sort between a disgraced doctor, his new lover, who was a veterinarian, and their exes. The accusation was that the doctor and the veterinarian hired a hitman to take out both of their exes. That hitman turned out to be an undercover police officer, and we are reviewing the testimony in that case. The defendant was on the witness stand. It got testy. It got heated. The prosecutor was just cornering him time and time again, coloring those conversations that he had with the undercover investigator in a very negative light. So let's break this down a little bit. Elura Nanos remains here. You didn't like my analogy. You said it wasn't a trapezoid. You said it was a rhombus. I disagree that the angles are equal. But look, what do you make of this thing? I mean, you got the defendant getting up there trying to basically say, oh, none of you are characterizing these conversations that I had with the undercover officer properly. I didn't really mean for anyone to be harmed. I was just asking if it was an option.
Yeah.
I mean, do we really split hairs that thin to differentiate between a question and a demand in that case?
I mean, we can, depending on who the conversation is with. I mean, there are definitely times that people who are close to one another, whether they're speaking in person or via text message or via email, there are intricacies in the relationship that maybe affect the context of a conversation. So as a general concept, that could work, but it doesn't work when the other person, A, is an undercover police officer who doesn't actually have a personal relationship with this guy. It doesn't work when the person on the stand is just not credible in any way about what he's testifying about. So theoretically it could work. It's just not working here.
It's not working here. I agree. Look, LaWanda Hodges is an attorney of the Atlanta, Georgia area. She's joining us now on Law and Crime Live. LaWanda, good to see you. What do you make of this? I mean, do you agree with us? Do you disagree? How's this guy coming across on the stand?
Well, two things I'd like to point out. In my experience, I usually do it on a case-by-case basis, whether or not I want someone to testify on his or her own behalf. I used to be a prosecutor for over a decade, and I'll tell you, on the cases where a person did not testify on his behalf, it definitely weighed heavily against them because the jurors want to hear that. So you have this piece where the jurors want to humanize you. You're sitting at a table, you're being talked about by the lawyers and all the other witnesses as the defendant. So they want to humanize you to a certain degree. And in those cases, the defendant sometimes needs to take the stand to humanize himself, particularly if it's involving like a sex crime. But I'll tell you, in my experience as a defense attorney, there's been times where I've advised my clients not to testify because I knew that there was a lot of incriminating evidence against him, and he or she may not be able to defend themselves on cross very well. And so in this case, I think that it was good for him to address the fact that, listen, you all may not like me, but I honestly did not want her killed. I just wanted her removed. I think he had to at least address that, because really all you need is one juror to believe you. And so I guess in that respect, I disagree to some degree that he should not have taken the stand, because I think the jury wanted to hear from him.
Well, I think the jury wanted to hear from him, but look, when you've got pictures being presented to the jury about the kidnapping that this undercover police officer staged, look at this stuff.
Right.
To then turn around and show that defendant, Leon Jacobs, hey, look, this is how it went down. I carried this all out. So, of course, again, these are staged, but the undercover officer, who the defendant thought was a hitman, I mean, look at this stuff. This is the length that the police department went through to try to catch this guy. They had the purported victims stage their own kidnappings and deaths to then go back to this guy and get his reaction. And again, of course, these are fake photos. These two were not harmed. That's the ex-girlfriend of this defendant and the ex-husband of his new lover. Okay, she's not involved in the prosecution because she committed suicide before trial, unfortunately. So that case didn't move forward. But look, he had to try to explain out of photos like that and trying to say that, oh, I really didn't mean for anything bad to happen. I was just asking questions about whether bad things like this could happen. I mean, is there really an explanation to get out of that?
No, I mean, there was definitely damning evidence against him. But again, at this point, if you have those types of photos shown to the jury and pretty much everything is against you, what do you have to lose? If you only need one person who can probably believe you and hang the jury, then it might be worth the risk. Because otherwise, what do? Just remain silent, and you have all this evidence against you, and you're not even attempting to do it, because there's no telling that the prosecutor, for instance, would have handled herself as well as she did on cross-examination. Maybe there was an opportunity for him to convince at least one person. And so it's really a case-by-case scenario. This case was definitely one that there was a lot of damning evidence. And obviously, he could have chosen not to testify. I don't think it necessarily hurt him. I think that at this point, with all that evidence being shown, the jury had already made up their minds. And if he wanted to at least try to convince one person, it was worthwhile testifying.
You know, you do make a good point. Maybe they felt that they were losing the case already at that point, and they really didn't have many other options, many other places to go. So let's continue reviewing the testimony now. Again, this is the Leon Jacob case out of Houston, Texas. This was a case where a disgraced doctor was accused of hiring a hitman to take out his ex-girlfriend and his new lover's ex-husband. Let's continue reviewing the testimony.
You mentioned that Valerie has a conversation with Javier, and you know nothing about what was said, right?
No, I do not. I did not at the time. I know now.
Well, you knew then too, didn't you?
No.
Well, because do you recall coming back to the table at the Olive Garden and Javier telling you she wants her ex-husband dead?
I don't really recall that. He may have said it, but I don't remember.
Do you recall Javier saying to you, so she's decided that she wants her ex to be gone?
I think he did say something to that effect, but he didn't use the word dead or killed.
That was my question. Do you recall Javier saying, so she's decided that she wants her ex to be gone?
I think if that's what you said, it said on the tape, and that's what it said.
Okay. And then your response was, I got it.
If you say so.
And then when just a few sentences later, your statement to Javier is, I can give you $2,500 a week for 4 weeks. That's probably the best and the easiest. Do you remember saying that, Mr. Jacob?
Something to that effect, yes.
So to tell the members of this jury that you didn't know what agreement Valerie and Javier had come up with, that's not exactly true, is it?
I knew about the agreement for the money, of course.
And what it was for, too.
I just told you I didn't know what it was for.
Well, do you recall that undercover officer trying to clarify what kind of car Matt drove?
I do.
And you clarified for him?
I don't think I clarified for him. I think she did.
And recall Valerie saying a Land Cruiser and Javier saying a Land Cruiser, and then you say, is that what type he's got?
Well, I think that your question would then actually depict a situation where I didn't know what kind of car he drove.
Were you clarifying what kind of car that Mac McDaniel drove?
To myself, yes.
Okay. And do you recall right after that, Javier saying a brand new Land Cruiser, carjack him, put a bullet in his head, throw him on the street, and make sure he's gone. Make sure he's dead for sure, and then park his truck in one of those apartment complexes. You know, one of those apartment complexes. When can I get the first payment? You recall Javier saying that to you?
The Olive Garden?
Yes, sir.
If you said that's what he said on the tape, and that's what he said.
That's what he said. And in direct response to that, you say, I can give you $2,500 a week for 4 weeks. That's probably the best and easiest.
And that's
correct?
the chronological order it happened in.
Right?
If you say it's the chronological order it happened in, then I have to say yes.
Okay, so you're agreeing to give him $2,500 just after he tells you, I'm going to put a bullet in his head and throw him on the street.
If that's what you say.
Well, that's in the recording. It's not what I say. It's what Javier and you said, right?
I guess.
You were upset when she obtained that protective order too, weren't you?
Which protective order are you talking about? The temporary one or the one we agreed to, the no contact order?
The temporary one.
Well, that came with the charges for assault and violence.
And you're upset about that, weren't you?
Well, of course I was upset about the assault and violence charges to begin with.
You were concerned that it might be public record that you had been asked to stay away from her, weren't you?
Now you're talking about something different.
Well, let's talk about the 2-year protective order. Were you concerned that it was made public?
It was agreed upon that it would be sealed.
And it wasn't, right?
No, it was not.
And you're frustrated about that, weren't you?
Well, typically when you're told by the law that they're going to do something and they don't, it's frustrating.
And you were frustrated, weren't you?
Of course I was.
Okay.
Leon Jacob on the witness stand, taking the stand in his own defense on charges that he hired an undercover police officer as a hitman to take out his former girlfriend. Now, he was also accused, along with his new lover, of helping her take out a hitman on her ex-husband. But let's really zero in on this back and forth between the defendant and his ex-girlfriend. Elura Nanos remains here in studio with me. Elura, look, if this guy had picked up the phone and dialed a pizza, that would have been harder than basically what the prosecutor did. They just called this guy up and ordered motive. Yeah. You know, it's like, and he served it right up like it was a pizza.
Absolutely. This guy literally was like, oh, did you need a motive? Here you go. Let me just give you one.
Yeah, here it is.
I mean,
15 minutes or less.
Seriously, this is potentially like one of the worst defenses, testimony in one's own defense I've ever seen. He's every time he has an opportunity to say something like, no, I wouldn't really have had a reason to have this woman killed. I would have been just fine had she still been around. Instead, he goes the complete other direction and says, oh, life would have been much easier for me without this woman causing all these problems. It's absurd. I don't really understand how anyone could have coached this guy to testify this way.
Yeah, real quick, LaWanda Hodges, let's talk about some of the answers here. He basically says, well, if that's what the transcript says, then I guess that's what happened. Is that sort of his way of admitting what he said without admitting what he said?
That's exactly what that is. That's being evasive, and he couldn't really wiggle his way out of it. There was nothing else for him to say. And to your point earlier, sometimes you may suggest that a person testifies, and then when they actually testifying, that you're like, oh my gosh, they're crashing. What are they doing? That was a classic case of what was going on. He was crashing. He didn't have any explanations for the questions that were posed to him, and answering, well, if that's what the transcript says, and I guess I did say that, wasn't a good response.
Yeah, I mean, ultimately, look, the prosecutor had the transcripts of what this guy said with the undercover police officer. He takes the stand anyway, and she just hit him back over and over and over and over again with everything he said, asked him to characterize it, forced him to eat his own words, and he's just saying, well, I guess that's what happened, and oh, by the way, my ex-girlfriend, quote, it was a hindrance. Well, that's one of those key words that will be argued on closing. So we're going to take a quick break. We'll be back with more analysis of the Leon Jacob case here on Law and Crime in just a second. Welcome back to Law and Crime Live, and thanks again if you're watching on the Crime Investigation Network on television. We continue to review the Leon Jacob case out of Houston, Texas. It's a case where a doctor who was struggling was accused of hiring a hitman to take out his ex-girlfriend. That hitman turned out to be an undercover police officer, and he was cross-examined harshly on the stand by the state.
Order in place, that affects your ability to get employment, doesn't it?
I don't necessarily think it does or does not. I was already employed.
You would agree with me that most employers probably are going to be a little bit cautious about hiring someone who has a 2-year protective order in place on them, right?
That's not for me to speculate. I already had a job. It didn't really concern me about my present employment, which is why I signed it voluntarily.
Yeah, there was no, it wasn't a contested hearing, was it?
No.
No. In fact, you all scratched out that language and all came to an agreement that you'd stay away from Megan.
It was a 2-year joint no contact order, yes.
Okay. And when you told Megan that you were frustrated that she got a protective order, which protective order were you talking about? Were you talking about the temporary one or the 2-year one?
I don't remember.
But you sent her an email after one of them went in place telling her, did you really get a protective order, didn't you?
You'd have to give me some dates and I could probably clarify that for you.
Judge, may I approach?
You may.
Mr. Jacob, I'm going to show you what's been entered into evidence as State's Exhibit 49, if you'll take a look at that for me.
The 29th of February. I can't recall which one I was referring to.
Okay, but you were mad about it.
Well, I was asking a question, do you seriously get a protection order against me?
And my question is, were you mad about it?
I was, a little upset. I was upset about it.
You're upset that a lower middle class girl from Pittsburgh had brought charges against you, weren't you?
It had nothing to do with where she was from.
Well, you mentioned it several times to the undercover officer, didn't you?
You're asking me two different questions.
No, I'm not. I'm asking you, did you mention to the undercover officer that Megan was a lower middle class girl from Pittsburgh?
That wasn't your question you asked me before. You asked me if I was upset that she ordered that characterization and she filed a protective order against me. So it's two questions. The first question was I upset that she had a protective order against me? The answer is yes. Her upbringing had nothing to do with that whatsoever.
Her upbringing was an issue to you, wasn't it?
No, it wasn't actually.
You felt like, how dare this lower middle class citizen bring charges against Dr. McDaniel or Dr. Jacob?
Not necessarily. I was more upset with her the fact that she lied to me about her education. She comes from a very, very nice family.
That's not what you told the undercover officer, is it?
I think I did at some point. I said that I like her family a lot.
You also told undercover officer, these are just lower class middle girls from Pittsburgh. You said that, right?
About characterizing Megan and one of her friends.
Correct. And at this point, you also believe that Mac McDaniel is dead.
Yes.
You believe that Officer Duran has taken care of Mac McDaniel, don't you?
That's what he told us, yes.
He told you that at the Willowwick apartment, right?
Yes.
And he told you that as you guys went out on the balcony, didn't he?
Either the balcony, yeah, somewhere in the apartment. He told us about it.
And after Officer Duran tells you that he's taking care of Mac McDaniel, Valerie actually excuses herself and goes back inside the condo, doesn't she?
Yes.
And that's when you stay out on the patio with Officer Duran, correct?
Yep.
And this man that you're so afraid of, you offered him a beer when he came in, didn't you?
Yeah, I think that, I don't remember which conversation it was, but yes, at some point we did have alcoholic drinks on the balcony.
And this man that you're so afraid of, you actually offered to let him have sushi with you guys too, right?
I think so, yes.
And this man that you're so afraid of, you actually told him that you felt like you had become friends with him and you wanted to stay in contact with him so he should touch base with you in the future, right?
I don't think it was out of so much comfort as I was you want me to continue, or?
Go ahead.
I'm not really sure I wanted to be friends with him. I really didn't know how to react around him.
Did you offer to help Officer Duran inject Megan with a syringe?
I think I did.
Did you offer to help Officer Duran inject Megan with potassium chloride?
I think I did.
Did you?
Yes.
And you know as a doctor that potassium chloride will kill someone.
Yes.
And so by helping him inject Megan with potassium chloride, it would result in her death.
That would be the logical conclusion.
It would be the conclusion.
Yes.
Wow, this guy was on the witness stand, defendant up there, trying to take his own defense, admitting that he was offering to help an alleged hired hitman kill someone. And it came right out of the defendant's own mouth. Elura Nanos. This guy seems to have thought he could get up there, he's a doctor, get everybody to believe him, get everybody to respect him. It crashed and burned.
Yeah, I mean, everything about this guy's testimony smacks of that sort of superiority. I'm going to assume that because I'm a big fancy doctor that I can just get away with doing whatever I want and everyone else is going to have to deal with the consequences. I don't see any indication whatsoever in this testimony that he's trying to ingratiate himself with the jury, that he's respectful of the prosecutor, that he understands his obligation to maybe help jurors make sense of something in a way that might look favorable to him. I just don't see him doing anything that's helping himself.
Yeah, I mean, he's getting up there and basically just trying to say, hey, okay, I did this. And as you said, everybody just deal with the consequences.
Right.
I thought that she was a hindrance to the future of my career.
I don't get it.
You know, I don't either.
I don't get it. I really do not understand why he is not there, at least attempting to offer something. For example, saying, you know, I was having a lapse in judgment, and this was something that I was considering, but you know, this wasn't really a direction. I mean, there are explanations he could come up with that might be somewhat helpful. He's just not making any of them.
Well, look, I mean, the facts should rule the day in any court of law. A trial is a fact-finding mission, and here the facts ultimately didn't work in favor of this defendant. We are continuing to monitor the situation as well in the Tex McIver case. That case is on lunch right now. We're going to continue reviewing the Leon Jacob case that we've been talking about when we come back from this brief break.
You were okay with Megan being taken out of state for your survival, right?
I never asked him to take her out of state.
You didn't ask her to be taken out of state?
I was told that's where she wanted to go.
Did you ask Officer Duran if he could take her out of state, and Officer Duran's response to you was, I don't know, there's some issues with that could be kind of problematic. Do you remember that in the recording?
I don't recall exactly what I said, but it could be something like that.
Isn't at the end of the day, what this is all about is your survival? I mean, do you recall telling Officer Duran, my survival is more important than anything?
I think I might have said that.
You said that, right?
Mm-hmm.
Yes?
I guess I did, yeah.
Judge, I pass the witness.
That was the tail end of cross-examination of the defendant himself, Leon Jacob. He was charged in Texas of hiring a hitman to take out his ex-girlfriend. Now that hitman turned out to be an undercover police officer, and ultimately that led to this prosecution. Elura Nanos, look, this guy ultimately admitted that he was helping this hitman, also known as a police officer, come up with ways to kill this woman.
Yeah, for somebody who just testified that, you know, he would do anything to help himself here, I mean, he's doing literally nothing to help his case. He is giving the prosecution motive. He's giving them details about how he committed this crime, and he's doing it all with this attitude of superiority and disdain for the prosecutor, instead of what he should be doing if he had any real interest in helping himself, which would be telling his side of the story in a way that at least attempted to ingratiate himself.
It seems like he was trying to go for an acquittal when maybe the strategy should have been to try to go to some kind of mitigation of punishment.
That seems like a good idea. And my money is on this guy being one of those clients that's impossible to wrangle. Every criminal defense lawyer has, and every lawyer has had these kind of clients where you tell them what to do and they do what they want to do anyway. And given his demeanor, I'm betting that this guy is one of those clients.
Yeah, this stuff just happened last night, folks. We're reviewing it in case you missed it. We are going to bring you the verdict in just a moment. This ultimately resulted in a punishment. We're going to review the verdict coming down. We will bring that to you in just a second. We have to take a brief break. You're watching Law and Crime Live, and thanks again for joining us on the Crime and Investigation Network as well.
As to cause number 1543813, State of Texas versus Leon Philip Jacob. We, the jury, find the defendant Leon Philip Jacob guilty of solicitation of capital murder as charged in the indictment signed by the foreman of the jury. Cause number 1543812. We, the jury, find the defendant Leon Philip Jacob guilty of solicitation of capital murder as charged in the indictment. All right, thank you. You may be seated. All right, ladies and gentlemen. Again, we're going to recess for today. We'll start fresh Monday morning. Same time, except I think Derek will explain to you, we'll be downstairs for the conclusion in the punishment phase. So have a good weekend. Please be prompt. We'll get started promptly on Monday morning at 9:30. And do not discuss punishment. What do you think you would do? What do you think with anybody, family, friends, anything like that? Okay? So, yes, we're going to poll you now, ladies and gentlemen, jury, which just means on the record we want your individual responses to ensure this was your individual verdict as to both cases. So, juror number 1, was this your individual verdict with regard to both cases?
Yes, Your Honor, it was.
And juror number 2, was this your individual verdict?
Yes, Your Honor.
Juror 3, was this your individual verdict?
Yes, Your Honor.
Juror 4, was this your individual verdict?
Yes, Your Honor.
Juror 5, was this your individual verdict?
Yes, sir.
Juror number 6, was this your individual verdict?
Yes, Your Honor.
Juror 7, was this your individual verdict?
Yes, Your Honor.
Juror 8, was this your individual verdict?
Yes, Your Honor.
Juror 9, was this your individual verdict?
Yes, Your Honor.
And juror 10, was this your individual verdict?
Yes,
Juror 11, was this your individual verdict?
Yes, Your Honor.
Juror 12, was this your individual verdict?
Yes, Your Honor.
Thank you so much. See you Monday morning, 9:30. Thank you.
All rise for the jury.
And there was the verdict in the guilt phase of this trial. From there, it moved forward to a penalty phase, and we're planning to bring that to you a little bit later on this afternoon. In the meantime, LaWanda Hodges, were you surprised necessarily by this decision ultimately to convict this defendant?
No, I wasn't. In light of the evidence that the state presented and in light of his testimony when he testified on his own behalf, I was not surprised.
Elura, you're here listening to this as well. I mean, we basically had the defendant admitting his role in suggesting a possible manner of death here. So not a surprise to you either, I'm sure.
Yeah, I think we can file this under totally predictable. This guy did a horrible job testifying in his own defense. We had lots of evidence. We had photographs. We had text messages. This is the way, this is the way the criminal justice system works. When there's obviously a lot of evidence, nothing great in defense, you get a conviction.
LaWanda, we were talking here before, and I'm wondering your thoughts on the matter. Should this defendant have been looking more towards mitigating punishment? In other words, looking potentially to a lesser sentence rather than trying to get out from underneath a guilty verdict in the first place? Now, keep in mind, again, we were in the guilt phase, not the penalty phase, but it seemed like he was trying to get out from underneath some facts that just were not able to, he was not able to get out from underneath them.
Absolutely. He had to make certain admissions because, again, they had the transcript, and I suppose the jury actually had a copy of the transcript as well. So he had to make certain admissions. He should have been trying to mitigate what happened, like you said, as opposed to just denying it, because there was no way for him to plausibly deny any of those things that he actually said.
Yeah, I mean, as far as mitigation, look, he was trying to say, okay, look, I didn't really ask for a hit to be taken out on my ex. I was just asking questions about whether or not it's possible. And, I suggested a couple of causes of death, but I didn't request it. Indeed, I said that I didn't really want anyone to be harmed. And I mean, this double speak, this saying one thing and asking another, jurors are going to look at it, they see through this, and we just saw the verdicts.
Absolutely. And also jurors are going to be offended by it because he's insulting their intelligence. And so there goes again this arrogance that he exudes, and just this idea that he is smarter than everyone else in the room is going to be offensive, and the jury's going to hold it against him. Unfortunately, he did himself a disservice by testifying on his own behalf in this case.
Well, one has to wonder what kind of advice he got from his attorney, because maybe the attorney said, hey, look, we know about this transcript. They're going to ask you about that question, that transcript, line by line, detail by detail. Everything you said, everything the undercover police officer said, all of that's going to come out. You're going to have to answer for it. So I suggest that you not take the stand. Now, that may have been the advice, but the client is the one who ultimately makes the decision. Could this be, and of course we won't know for sure because it's privileged, but could this be a situation where the client just completely disregarded the advice?
Absolutely. And sometimes they do. I mean, you can only advise them but so much. But ultimately, like you indicated, they have to make the decision that works for them. And the judge even advised them that, listen, you are presumed innocent. You do not have to take the stand. Have you been informed by your attorney that you do not have to take the stand? Usually there's this conversation between the judge and the defendant before the jury comes back into the room and before the defendant actually takes the stand. And so it's very plausible that that was, in fact, the conversation between the defendant and his attorney. He was advised not to testify on his own behalf. But back to our conversation earlier, in a situation like this, when everything is against you, where all the evidence is piling up, sometimes it's like, well, what else do I have to lose? I might as well at least try to get one person to side with me so I can go for a hung jury, or at least in mitigation of my sentence.
Well, look, the bottom line is we have a conviction in this case. Leon Jacob will be spending some time being punished. The question is what his punishment would be. This trial moved into a second phase, a sentencing phase, and that phase also got dramatic. We're planning on bringing you that sentencing phase later this afternoon, if you can stick around. We are also continuing to monitor the Tex McIver case in Atlanta, Georgia. So we will be talking about that in a little bit. That's when we come back here on the Law and Crime Network. Thanks again if you're joining us on the Crime and Investigation Network on television. All right, that's some of the testimony from yesterday in the Tex McIver case, the case of an attorney accused of murdering his wife. The defendant says it was an accident. It's a question of which side the jury is going to believe, as always. Was it intentional? Was it an accident? LaWanda Hodges, we've got a lot of back and forth about wills here, property, a husband and wife with separate finances. She loaned him money. That influenced the way that they owned this ranch together. She wanted the ranch to go to the godson. He may have had other plans with it. Earlier this morning, they called a law professor to try to explain wills, trusts, and estates law to the jury. This is the most complex murder case I can remember in a long time.
I agree. What I believe the prosecution is getting at, as you mentioned, is the motive. Because one of the crux of this case is whether or not he had the intent to do what was ultimately done, and that's the death of his wife. And so, of course, the defense is alleging that it was an accident, which is an affirmative defense, and they have a right to allege that it was an accident, it was a case of misfortune. But the prosecution, on the other hand, is saying that, well, you know what, intent can be inferred. And you can infer intent from the circumstances surrounding the event. And that's why they're bringing in the fact that the defendant had arguably financial problems, that he wasn't making the money that he used to make as a lawyer at his law firm, and he was actually relying on the victim to carry the weight for the ranch and for other aspects of their lives. And then that's why the will becomes relevant to some degree, because if she wanted or they had intent to change the will at some point, and he never did, it goes to whether or not his mind state or his mental state at the time of the murder was to get rid of her so he could arguably get her funds. I think that's what the prosecution is getting about, and I think that's why it seems relatively convoluted, but it's really important for them to explain the intent and the motive. They go hand in hand. In a murder case in Georgia, you actually don't have to explain motive. Like, there's a jury instruction that explains that motive does not have to be proven, but the intent aspect does, the criminal intent.
Yeah, exactly. And if some states require motive, some don't. But it's helpful to have it even if the statute doesn't require it. And here, look, they're talking about some conversations back and forth between the victim and the defendant, the wife and the husband, which go back 5 years before the bullet ever came out of the gun. And, a disagreement over where some property would go from 5-6 years ago that may not have ever been fully resolved, that suddenly plays into motive or possibly intent some 4, 5, 6 years later? I mean, is it too disconnected for the jury to buy it?
Well, that's the argument. That's the argument that I'm sure the defense is going to make, that this is too disconnected. It's not close in time. What is actually relevant is what was their relationship like at the time of the incident in 2016. That's the question, and that's the argument the defense will make. But the prosecution, of course, they are not only relying on this changing of the will, but they're also relying on the circumstances that happened just before the shooting. Like they're talking about his influencing or arguably influencing witnesses at the hospital. Ms. Carter, who was the main witness in the car, his conversation with her. They're talking about how he behaved at the hospital when his wife was in trauma, in very critical condition. What was his behavior? Was his behavior consistent with a husband whose wife was dying? They're talking about conversations he had with other friends about the Social Security. Was he in fact acting like a person who had just lost his wife? All those things go into intent, including the will that might have been an issue 5 years prior.
LaWanda, I know you need to take off here in a couple of minutes, so I wanted to thank you for joining us here on Law and Crime. In the meantime, let's review some of the testimony that happened yesterday. This is Ann Schwall. She's the mother of the godson who the victim wanted ultimately to inherit the ranch. Here's some of the way that she characterized some of those conversations.
There's only one 807 notice.
Right, that was my...
That's fine. Okay, I understand. Do you recall where you were when she told you that she wanted Austin to have the ranch?
I believe we were at the ranch.
Okay. Now, after Diane's death, did you become aware that there was a will that was probated for Diane McIver from 2006?
I did.
Okay. And can you tell the jury, based on the information that you knew about the 2006 will of Diane McIver, was Austin named in the 2006 will to get the ranch? Let me see if I can lay a little foundation.
Okay.
First, if you could tell the judge, how do you know about the 2006 will?
I found out after her death.
Okay. Have you ever had the opportunity to actually see the 2006 will or a copy of it?
No.
Okay. Can you tell the jury, after the death of Diane McIver, did you have a conversation with the defendant about Diane's 2006 will?
I did.
Can you tell the jury when was the first time you would have had this conversation with him about Diane's 2006 will?
It was after her death.
I think a couple of days, a day, a week, a month?
It was a couple of days after.
Okay. And can you tell the jurors what did you say to him about Diane's 2006 will?
What did I say to him?
Mm-hmm. How did the conversation come up? It's probably a better question.
He told me that his biggest regret was that they did not get a chance to change their wills, update their wills.
And can you tell the jurors this was in regards to what?
Just after her death, there was just a lot of, I guess, business just, going on with the, what a funeral or planning and discussions, and he just said that to me when I was at the condo.
Okay. And did Austin come up in that conversation with respect to what Diane told you, which was she wanted Austin to have the ranch. Did you talk to the defendant about that?
I did. He said that that was his biggest regret, was that they did not get around to updating their wills, because that was something that she wanted.
Right.
Testimony there in the Tex McIver case out of Atlanta, Georgia, ultimately saying that the person, Austin, who the victim wanted to receive some property upon her death, would have gotten it anyway, because Tex McIver agreed after the victim's death to go ahead and grant it to him anyway. So, Elura Nanos. It seems that that deflated a lot of the state's motive, because ultimately, even though it wasn't set in stone at the time the victim died, ultimately, Tex McIver said, I'll go along with her wishes.
Yeah, I really think that putting this degree of emphasis on this whole estate and wills issue is a serious misstep on the part of the prosecution here. I think it's too complicated. I think it's not dramatic enough. And look, the prosecution has to do something, because as we talked about before, you know, the prosecution does need to prove intent. And in a case like this, where we know what happened, we know that the victim died, we know that she died as a result of being shot in that car, there has to be some proof of intent offered up. And the only way we're going to get that intent is by inferring the intent based on surrounding circumstances and background information.
Yeah, I want to show people what's going on live in the Tex McIver case right now. They just came back from lunch a few moments ago. There is a professor of wills, trusts, and estates law who's about to face cross-examination. If you want to watch the trial in its entirety, you can always go to our website. That's lawandcrime.com. There you can click on the live tab and see all of the raw feeds as they come in to us. But ultimately, Elura, this is really convoluted stuff. These were what a law firm would refer to as two sophisticated clients.
That's
you
right.
have a high-power attorney who had some big-name clients. He was a partner at a big firm, okay, was making close to $500,000 a year himself, and his wife, the victim, who was a business CEO. Sophisticated clients. They had complicated financial affairs.
Sure.
And they have to unwind all of this in front of the jury to try to go through it line by line by line. It takes hours.
And I just don't think it's helpful. I really don't, because I think the jury's going to walk away saying, look, these are two people with a lot of money and some sophistication, and it's reasonable that married people would disagree about certain business or estate decisions, and there's nothing wrong with that. And it really doesn't necessarily mean that one person killed the other one over it. I think we would need something a little bit more dramatic than just, this is what I want to go into my will and this is what I want to happen with my estate.
Well, that's one way to look at it. Another way to look at it would be some jurors sitting there saying, hey, look, if these two people had the loving relationship that many of the witnesses have told us that they had, then she wouldn't be loaning him money which could have affected his ownership interest in this ranch that they both loved. And could the loan have meant that she could have bought out his ownership interest underneath him, and then she could have given it away, ripped the rug out from underneath him, and that bothered him, and that's the reason why he did this and made it look like an accident? I mean, could go that way too.
You know, I see where you're going, and I think what, you know, the point there is married people don't usually do this. They don't usually loan each other large sums of money. So that in and of itself is unusual. And I think, though, what we need is a more sort of sinister reason for that. I want more information about, well, maybe this couple wasn't as loving as people are saying they were. Maybe there was more behind the scenes drama. But just knowing that there was a loan, to me, is not compelling enough, because who knows, maybe there were tax implications for that loan. Maybe there was a perfectly innocent reason for that. Or, as you suggested, maybe it really does point to, you know, a breakdown of that relationship or something odd about how the relationship works. So my point is, yeah, maybe that'll work, but I kind of want more, because without it, I'm just seeing two rich people, some sophistication, and some kind of business dispute. But I'm not seeing a motive really for murder there.
Oh, gosh. I mean, the details in this case, look, you go layer upon layer upon layer. Maybe at the 10th layer, we see, aha. He tried to hide this under all these layers, and that's the key part. That's the intent. We don't know.
But 2 hours of property law instruction in front of a jury is not going to help them get to that moment.
Yeah, let's continue to monitor the situation there. We're going to be back dialing this case all the way back to opening statements when we come back here on the Law and Crime Network. Welcome back. You're watching Law and Crime Live, and thanks again to those of you joining us on the Crime and Investigation Network. We're talking about the Tex McIver case out of Atlanta, Georgia, the case of an attorney who's accused of murdering his business executive wife, rather. This is a convoluted case involving separate finances, changes to wills, and the state says it adds up to intent for murder. The defendant says it was all an accident. Let's dial all the way back to opening statements in this case to try to put what's happening now into some context.
And never in that version did he say anything about Black Lives Matter or a bump. After Diane McIver died, less than a week after she died, the defendant began to inventory all of her belongings. Her jewelry, her clothes, her hats, shoes, everything that she had, he began to inventory it so that he could sell it. And what the defendant told media outlets and journalists is that he was doing this in order to satisfy the bequests in her will. And he had an estate sale and an auction and raised over $187,000. And the evidence will show that to this date, not one of those bequests.
Prosecution opening statements there in brief in the Tex McIver case. Elura Nanos, let's talk about this a little bit more. Here's some of the facts. So the highway's backed up. The friend, Danny Jo Carter, is driving the car. She gets off trying to get around this obstruction in the interstate. We've all done it, tried to loop around and hope it saves us time. They wind up in what Tex McIver, the defendant, thinks is a bad neighborhood. He's in the back seat. His wife's in the passenger front seat right in front of him. The friend is driving. Tex McIver asks for his gun, fearing that there might be some danger in the neighborhood. Okay, and that's how the whole chain of events started to unfold.
Yeah, and you know, so the way I feel when I hear the prosecution's take on this case and I hear those facts is that it's kind of like, okay, it makes sense, and then all of a sudden, what? And that's how I feel every time we get one more foot into this case. So yeah, it makes sense that they were driving and that they pulled over and they decided to go a different route. It even makes sense to me just rationally that, you know, that Tex McIver might have said, okay, this seems like a shady neighborhood, let me get my gun. That works for me. What doesn't make sense is then at that point, he is given the gun by his wife and he falls asleep with it. I mean, well, which was it?
In his lap, and it's wrapped up in this grocery bag, and, you know, questions about whether or not the gun was cocked or not, because if it was cocked, it's a lot easier to pull the trigger.
Sure.
If it was not, you have to exert something like 6 times the amount of pressure on the trigger to get it to go off. And, you know, his attorney in interrogation said the gun was not cocked. Well, then you got to put a lot of pressure on that trigger to pull it back. You know, and what do we make of it being wrapped up in this grocery bag? He's fallen asleep. It's in a grocery bag. You need all this pressure to pull the trigger.
Weird.
And he says it's an accident.
Yeah, it just seems weird. Now, I'm not saying that it couldn't have happened. It could have happened that way. It just seems very unlikely to me. There are too many pieces that don't add up for me. It's weird to keep a gun in a grocery bag. It's weird that he would have known enough to say, I need my gun, but then also have been, you know, out of it enough to be falling asleep with the gun. And then if he was asleep, how did he shoot it, whether it was cocked or not cocked? It doesn't even make sense.
Yeah, let's listen to some of the defense's opening statements now in this case and see how they characterize what happened.
Tex wasn't trying to bribe the DA. He wasn't attempting to commit a crime. Jeff Dickerson, I think the evidence will show, didn't think that Tex actually meant he ought to go bribe the DA because Jeff Dickerson doesn't go tell Tex's lawyers, hey, you know what, your client just told me that I needed to go commit a crime, that I needed to try to bribe the DA. He doesn't go tell Paul Howard, hey, Tex McIver just tried to get me to commit a crime. He doesn't tell anybody about this conversation until some 14 months later. And, most importantly, Jeff Dickerson doesn't quit working for Tex. He continues to be paid about $3,000 a month. That shows he didn't think Tex was seriously intending that Jeff Dickerson go bribe the DA. This some 14 months later, that Jeff Dickerson is having what appears to be a casual lunch between friends with Paul Howard when he is no longer working for Tex McIver, and somehow this comes up. Why Jeff Dickerson mentions it to Paul Howard, I don't know. The thing I know that the evidence will show is that it was not an intentional statement. It was not a serious attempt to bribe the DA. It was a comment that has been misinterpreted. The evidence is going to show that the gun was held sideways, that it was shot through the plastic bag, as I said, that it was shot through the car seat, which had all the interior mechanical workings, that the evidence will show the bullet could have been deflected or slowed down or come apart. The evidence is going to show that the gun entered Mrs. McIver's back in her lower to middle back. And then finally, the evidence is going to show that Tex was relying on Diane's substantial cash flow and income every month, and there was no financial reason for him to cut that off. The evidence is going to show to you, ladies and gentlemen, that Tex loved Diane and Diane.
That was some of the defense's opening statement in the Tex McIver murder trial out of Atlanta, Georgia. It's a case involving a former prominent attorney who is accused of killing his business CEO wife. The defendant says it was all rather an accident, and it started when they were heading down the highway, traffic backed up, and the driver of the car got off the highway and headed through what the defendant thought was a bad neighborhood. He asked for his gun, claimed he fell asleep with it in his lap, and when they hit a bump or stopped or something also interrupted their trip, the gun went off. The bullet went through the seat and struck the defendant's wife, who was sitting in the front passenger seat. We'll review more with the Tex McIver case in a moment. We also want to talk about something coming up in about 40 minutes here on the Law and Crime Network. We are planning to cover the arraignment of the boss of Michigan State University, Dr. Larry Nasser. Now, many of you remember the hearings for the Larry Nasser case, which we also streamed live here on Law and Crime. That case involved a doctor who admitted to sexually abusing a number of athletes. The boss is in trouble now. We'll bring that to you in a bit. We're going to take a quick break. We'll be back with more after this. Welcome back, everybody. You're watching Law and Crime Live, and welcome again to those of you joining us on a special simulcast with the Crime and Investigation Network. Elura, we're still here. We're also going to continue to talk about the Tex McIver case, which is back underway. Some back and forth there about whether or not a reporter is going to take the stand. They've been arguing about that today. Apparently, this reporter has some information that they really want to get in front of the jury. Some states have shield laws. Reporters can't be called to testify. Georgia apparently does not, and there's been a lot of background legal wrangling with that right now.
Yeah, I'd really like to hear where that's going. I'd be very interested to hear what a reporter might have to say, because from my point of view, what this case is sort of lacking so far is the kind of drama in the facts. You know, I'm looking for, well, what is really the motive? You know, am I to believe that the motive here for murder is really about estate law and wills? I want to know more about this couple's marriage and what their relationship had been like. And I think it's quite possible that a reporter, somebody who is seasoned in the media, someone who has an interest in sort of bringing out the salacious, might actually have those kind of details that would kind of round things out a little more and be sort of the counterpoint to, you know, what a law professor might have testified about.
Yeah, certainly a different set of factual circumstances. But look, the prosecutor apparently stood up in court and said this reporter is going to testify. The television station's attorney is apparently saying, no, that's not going to happen. And there's a lot of wrangling going on as this trial progresses as to exactly which witnesses are going to take the stand. So, I mean, look, there's always three different arguments. There's the one you plan to make, the one you actually make, and the one that you wish you made, and this is changing as it goes.
Yeah, that's very true. And I think, you know, here we'll see from the legal standpoint, you know, what's going to happen with that reporter. And you know, generally speaking, the idea of forcing a reporter to come to court is something that judges don't like to do. And, you know, you mentioned before some states have shield laws. Others don't have that law as a universal shield. But that still means means that, we treat reporters and members of the media a little bit differently when it comes to courtroom antics. So, we may see how that plays out in this case.
Yeah, we're going to continue our review of the Tex McIver case. Now, a friend who worked with the victim, Diane McIver, was testifying about exactly what the defendant said not long after her death. So let's continue to review testimony there, and we'll be back with more analysis in a bit.
He called me on my cell phone. I was at my fiance's house getting ready to get in the shower to get dressed for work, and my phone rang, and I answered it, and it was Tex.
Okay. And can you tell the jurors what did he say to you?
He said, Diane's. Excuse me. Can I have a bottle of water, please?
You good? Just water?
Yes, sir. I've got a couple. Thank
Oh,
you.
you got some right?
Yes, sir.
If you need a break, let us know.
Time's up. Said I wasn't going to do this. He said, Diane's dead. And I said, what? What are you talking about? And the only thing I really recall after that is the words car and accident. And I don't know whether he said we were in the car and it was an accident, or whether it was a car accident. I don't know. I recall the words car and accident. And he asked me if I would go tell Billy, meaning Mr. Corey. And I said I would.
That was Jay Grover on the witness stand. He worked with victim Diane McIver, and like many witnesses, he was overcome with emotion, trying to recall the moments he learned about his beloved co-worker's death. That was his testimony. We want to show you what's happening in court live right now in the Tex McIver case. A reminder that if you would like to continue to watch the trial in its entirety, we have that for you. You can go to lawandcrime.com, click on the live tab, and there you can see all of the cases as they come into us in their raw, uncut format. This is a law professor who was called to the stand by the prosecution to try to help the jury untangle the very complex property ownership, financial arrangement, estate plan, etc. that had been put together by both the victim and the defendant. Let's listen.
Well, to understand who the property would go to if you didn't have a will, and to understand what disposition, what distribution you're setting out in your will.
Okay. A wife doesn't need her husband's permission to change her will.
That's correct.
Vice versa, a husband doesn't need his wife's permission to change his will.
That's correct.
You don't have to get the permission of any of the beneficiaries named in your will in order to change it.
That's correct.
Okay. So if Mr. McIver was free to change his will at any time, Diane McIver was free to change her will at any time, correct?
That's correct.
That was live testimony as it unfolds in the Tex McIver case out of Atlanta, Georgia, the case of an attorney accused of killing his business CEO wife. That's an estate law professor trying to explain to the jury exactly what was going on between the victim and the defendant. We're going to take a break. We'll be back live in just a moment.
So the question, if you'll repeat your question. Okay. Why didn't you call 911?
My phone was in the back seat because I really hadn't been able to use it all weekend.
So where was it in the back seat?
In my purse.
Why didn't you use Diane McIver's phone? Did she have a phone?
Yes, I didn't know where it was, and at that time I was driving, and even if it was down here in the console, I couldn't look down to get it.
Can you tell the jurors, did you know whether or not the defendant had a phone?
Well, I knew he had a phone. Yes.
Where was it?
It was in the back.
If I were to guess, this is the part of the trial that jurors will want to listen to over and over again as they try to unwind exactly what happened here. Because there were only 2 witnesses who were in that car who were alive. That was one of them. The defendant is the other one, and it's unclear whether he'll take the stand. So, Elura Nanos, this is the witness who at least saw some of what happened and how it went down. How he was holding the gun was in the bag, what position the gun was in. She didn't see all of it, but what she did see is really critical in this case.
Yeah, I mean, this is an eyewitness, and granted, you know, she doesn't know exactly what was going on in the defendant's head. She was driving a car, so she doesn't know exactly some of the more minute details of this, but she was there. She knew what had happened, or maybe more importantly, what did not happen directly before that, before Diane McIver ended up being shot. She can give context to the surrounding circumstances and to the defendant's reaction immediately afterward. So, I mean, it really doesn't get any better than this testimony.
Let's talk about the courtroom being a theater. If the courtroom is a theater, the prosecution had the right props. I mean, these are the actual seats from the vehicle. And we got the witness off the stand. We saw the witness sort of say, this is how I was sitting. This is where other people were sitting. They had other people sitting in place of the victim and the defendant. But that just helps the jury really get into things and say, okay, we understand how it happened now.
Yeah, I mean, and I think it's absolutely critical in this situation because basically we're going to come down to 2 sort of compelling stories here. There's going to be the part of the story that is the exact details of how Diane McIver died and how she was shot, and that whole theater is very important to that piece. And the other piece is going to be whatever the prosecution can piece together in their obligation to come up with proving intent on behalf of the defendant. So I do think that creating the drama and doing their best to recreate what happened is absolutely essential here.
She was on the stand for hours and hours, and this eyewitness testimony, it's a lot easier to listen to than the convoluted nature of the will and the estate and how the property was owned and in what percentages, and did this loan between the 2 affect it. But in order to get to that murder charge, you've got to get to that key word we've been talking about, that's intent. And without the will testimony, what happened in this car might not get to that top charge.
Right, because, I mean, if you look at the facts that we know, that are even the facts that are uncontested about the shooting and about that drive, there is at least a fair chance that this could just have been an accident. So we really need more to know that it's a crime.
We do. We're continuing to monitor the Tex McIver case, but we're going to take a brief break. We'll be back with more here on the Law and Crime Network in just a few moments.
And what's the next thing that you can, I know you said you kind of fell asleep there, what's the next thing that you can remember from there?
Despite the fact I was tired, I don't sleep well in cars. Right. But we went through an area I thought that was particularly dangerous at night. That's one that has a particularly high population of homeless people. Okay. And at least in the daytime. But at night, there were a lot of people there. Okay. And I quickly said, this is a big mistake, and we're in a place that we don't belong. Right. And I said, I'd like to, if you don't mind, please hand me my gun. Right. So Diane reaches in, pulls it out, hands it back to me, and by then we may have been on Piedmont. Anyway, I'm relatively satisfied that we're out of that kind of area. Right. And I guess I just laid back again and went to sleep. Okay. But she came to a stop, and I was handling the gun. I realized it was in my lap, right, and it went off. Okay.
So there you have the defendant, Tex McIver, in an interrogation room explaining to police interrogators exactly how the gun went off in his words. Now, Elura, this might be the only chance that the jury has to actually listen to words coming out of the defendant's own mouth. He doesn't have to take the stand. Of course, he might, but that interrogation might be what they see. I watched the whole thing. He was pretty cool. He was pretty collected. He got emotional when he talked about his wife's passing. He explained things. It was relatively cordial. He walked in the room flanked by his two attorneys and shook hands with the interrogators before they interrogated him. It's a different kind of interrogation than what we're used to seeing here.
Yes, I think that's right, and I think that that fact really won't be lost on the jury, that they'll look at this and say, he's not acting in any way that is overtly suspicious.
He's not doing anything that raises immediate, presumptions of guilt. He's not doing anything erratic. He's not being disrespectful. And I think that those things are important, particularly in the case of a defendant who does not testify in his own defense. I will say that I think in this case, although we've talked a lot today about the risk it can be for a defendant to testify on his own behalf, I do think that in this case, this is the kind of case that if the defendant does not take the stand, the jurors really may sort of hold that against him. They may need to hear from him. They may need to hear his account of how this was an accident, how, what he was feeling before, during, and after. It may be that kind of case where they really want to hear this defendant say, this was a terrible accident. Here's how it happened. Here's how I feel about it. And if he chooses not to do that, although he has no legal requirement to do that, I do think that it could have, it's sort of an emotional or analytical effect on the jury.
Look, we've got the top charge. We've got murder. We have lesser included charges here. Part of me is wondering if the jurors might latch on to those because they might not be able to get to that intent. They might not get into the whole argument about the will and, that's just what people with a lot of property do. They disagree on who's going to get it, whatever. But, they could turn around and say something just isn't right here with these statements that we heard a few minutes ago from Danny Jo Carter, where she says things like, quote, I cannot lie. And saying, I can't tell the police what you're suggesting that I say to them. That stuff's going to leave a really bad taste in the mouths of the jurors, I suspect.
I absolutely agree. And like we see so many times, very often, it's not the underlying crime, but it's the cover-up that gets people in trouble. And I think that there is no way at all to look at a situation where anyone tries to get someone to change a story to police, even if the underlying circumstances were innocent. That request to change a story to police looks terrible. The jury is going to have a hard time discounting it.
And again, does that necessarily make him guilty of murder, or does it just characterize him as sort of a big shot attorney at a big firm who's used to being able to control the process? And here, control slipped through his fingers and he just basically can't order people around. He doesn't have his hands on the reins the way he normally would.
You're right. And it doesn't make him a murderer. What it does is it makes him look bad.
Okay, folks, we are monitoring a arraignment for a boss of Larry Nasser's at Michigan State University. Let's go to that hearing.
Laura Moody of our office. My P number is 40771.
Last name Rollston?
Rollstin, yes, sir.
Thank you. Be seated. Mr. Detmack, would you like me to read the charges into the record?
We'll wait reading.
Okay, folks, I hate to do this to you, but we do need to take a break. This is an arraignment for the boss of Larry Nasser, the Michigan State University doctor who admitted to sexually abusing more than 100 athletes. The boss has been arrested. We're listening to that hearing. We'll recap it when we come back in just a moment. Okay, folks, we were just listening to the arraignment of William Strample. He was a boss, a dean at Michigan State University. This ties into the Larry Nasser gymnastics investigation. Of course, we know Larry Nasser got these hundreds of years in prison related to sexual abuse of female athletes. Well, this was Larry Nasser's boss, and I'm just taking a look right now at the criminal complaint that was filed against this guy. This is what he's facing: criminal sexual conduct with force, misconduct of a public official, neglect of duty as a public officer. These are some of the accusations. They got into this investigation as part of the Attorney General's investigation into MSU in the wake of the Larry Nasser mess. Now, here are just some of the factual accusations contained in a criminal complaint document. This defendant, William Strample, who we just saw arraigned, on his work computer had pornographic videos and a video of Dr. Larry Nasser performing his alleged treatment on a young female patient. Now, this is the link that many of the victims have been talking about in the Nasser case. They have said people further up the chain knew what was going on and didn't act to stop it. One of the accusations here is that this guy had videos of Larry Nasser's abuse on his computer. There's more. This defendant is accused of soliciting nude photos from at least one female medical student. There are a lot of accusations in this complaint document. This is big. Elura, when I read some of these to you in the midst of that hearing, I've seen you in various states of shock over the time that we've known one another. This was the biggest shock that I recognized in your face, excuse me.
Yeah, this is really pretty shocking. And, we had talked off camera quite a bit about, what might come up in this arraignment. And all of us here at Law and Crime, sort of opined that, this guy, Strample, he may have had something to hide. Maybe he had suspicions about Larry Nasser. Maybe he had some wrongdoing on his own. And those were the factors that contributed to him not saying anything, turning a blind eye to what may have been suspicions. But this is not suspicion. This is clear evidence that this guy knew and had a videotape of Larry Nasser. I honestly cannot imagine anything more dramatic in this case.
Well, look, I mean, we've been talking about reform in this case going back to the hearings. And look, there's something that I've learned over my time as a journalist, years and years and years, that, look, bad people do bad things, okay? And oftentimes they're caught. They might do one or two bad things or maybe even three or four, but usually the system or the people around them close in, blow the whistle, something happens, police, authorities, whatnot, there's an arrest. Whenever there is a situation anywhere where complaint upon complaint just piles up, and that's what we had in the Larry Nasser case, more than 100 victims. Whenever something is that serious, a bell goes off in my mind and I say something is wrong with the system or the people who surround the accused that didn't catch what happened.
Yeah.
Okay, and we've been talking a lot. I did a lot of research into the mandatory reporting laws. Why in Michigan were the laws not that strong? Some states say you have to report this stuff when you hear about it. Well, in Michigan, the law is really weak. Well, guess what? Okay, they finally found a way to try to get this guy if the accusations are true, but the law could have been stronger. And now we have what appears to be smoking gun evidence against this guy.
So, and I'll tell you, one of the things, really one of the tragic things that we see that has particular relevance with respect to sexual misconduct is that so often you have people on the sidelines of some kind of abuser who, they just really don't want to get involved. And often the reason why is because they don't have really hard evidence. They have a feeling, a suspicion, something like that. Here, the fact that this man had videotape, it is so inexcusable and so outrageous that it is perhaps the worst thing that I could imagine someone in that position doing.
Well, look, the victims have been brave. They have demanded investigations. The investigation happened. This is one of the upshots of it. We have new charges. But we're also talking about the Tex McIver case in Atlanta, Georgia, here on the Law and Crime Network. We're going to dip back into that courtroom. There is an attorney on the stand who practices in the area of property law. This is just another of the expert witnesses the state has called to try to help the jurors understand the complex relationship between the victim and the defendant. Let's listen to that for just a bit.